I'm James Swartz, managing attorney at Swartz & Swartz. So questions come up all the time about what negligence really means. How is it defined? Perhaps the best way to explain that is to use real-world examples of negligence to show in different contexts what that looks like. So for example, in a car accident crash, a drunk driver may speed through a stop sign and broadside your car, causing injuries. There might be a pedestrian accident that happens because a driver is texting or emailing while driving and speeds through an intersection and causes injury to that person in the crosswalk or the sidewalk. There are dog bite injury cases where, let's say, a child is passing somebody's property, a dog who is off leash runs off the property and bites that child, causing injury. An example of a slip and fall accident at a supermarket might involve a shopper slipping on water or slippery substance, suffering a shoulder injury, and there was a failure to warn or to put up signs by the retailer indicating that there was a problem in the area. An example of a medical malpractice case might include where a doctor fails to diagnose the signs and symptoms of cancer, and as a result, due to the delay, the cancer spreads and causes severe injury to the client and even in some instances, death. So with respect to all of those examples of real-world personal injury cases and negligence, what are the core elements that need to be proven? In any negligence case, a duty of care needs to be shown, meaning that the defendant has to be shown to owe a duty to the injured party. So in the medical malpractice example, when a doctor takes on a patient and cares for that patient, that doctor has assumed a duty to that person to exercise reasonable care to make sure that the procedures, evaluations, operations are all done according to the standard of care for that doctor's profession. Also, in addition to showing duty of care, there needs to be a breach of that duty. So using the example of medical malpractice, did the actions of that doctor fall below what is expected of that doctor in that situation? Finally, there needs to be causation and damages. So causation simply means that when a breach of duty is shown, there has to be a connection between that breach and the injuries that are alleged to have been suffered. In many cases, it may be that there are multiple causes of the same accident. So for example, if somebody falls down a stairway at their apartment complex due to the failure to fix the lighting in the area or to fix a broken handrail, if that person is shown to have been intoxicated, that would be arguably another reason for the happening of that accident. Finally, it's important to understand in Massachusetts the concept of comparative negligence. So what that means is that the plaintiff may be shown to have been negligent in addition to the negligence of the defendant or the responsible party against whom the case is brought. In Massachusetts, if the plaintiff's negligence is greater than the defendant's negligence, that is 51% or more, that plaintiff can't recover. If the plaintiff's negligence is shown to be below 50%, then that percentage is deducted from the final recovery. If you have questions about a personal injury caused by someone else's negligence, contact Swartz & Swartz.